Good evening, this is John Milburn for Laws 19038, Planning and Environment Law. This is week 8. We're dealing tonight with protection of biodiversity and climate change. And of course, we're getting close to the point where I can release the results of our first assessment. Overall, I've got to say I'm very happy with the work that has been presented to me. The final cut-off for presentation material is Saturday. That is 2 days from now, the 7th of May. If you haven't submitted your work by 11:45 p.m. on Saturday the 7th of May, then I won't accept it. I do hope to release the results and feedback, which will be audio feedback, on Sunday. Now, in terms of the reading for tonight, there are a number of chapters in Bates that you need to consider. There's the one problem there as well. And from the chapters are 11, 12, 13 and 16. Okay, I won't repeat what's in the material, but I'd refer you to Bates, those chapters, refer you, of course, to my notes, which you'll find on Moodle as well. So in terms of protecting the biodiversity and climate change issue, we need to firstly consider the international obligations imposed upon signatory nations such as Australia, and the starting point for that would be the Earth Summit. The 1992 Rio Earth Summit is really important. So have a look at that, because that is from that the whole issue of biological diversity and protection of the biology was created. So that's the Convention on Biological Diversity. When a signature nation signs, it doesn't actually become part of the domestic law. The nation needs to enact legislation which reflects the international obligation. Now, of course, in Australia there's a problem because the federal government didn't have the power under its constitution to make that law. However, as a result of cooperative arrangements through COAG in 1992 and the bilateral agreements regime, the Commonwealth was able to enact the Environment Protection and Biodiversity Conservation Act in 1999. Now, of course, that's the primary piece of legislation in relation to planning and environment law at a Commonwealth level. And if you'll have a look at Chapter 5 of the EPBCA, you'll see it covers a range of different issues that are important in terms of protecting the environment. So the main ones are identifying and monitoring biodiversity and making bioregional plans. That's one aspect. The other aspect is species and communities. Then there's conservation agreements, and finally protected areas. Now, just for the sake of selecting one of those, I'll go with protected areas, and you'll see that there are 9 different types of protected areas referred to in the legislation, and 2 of those, just to highlight them, are the Great Barrier Reef and also Commonwealth reserves. Just to give you an example of how this works in the legislation, in terms of Commonwealth reserves, have a look at sections 344 and 345 of EPBCA, and you'll see that the Governor-General may by proclamation declare any area of land or sea as Commonwealth reserve. And but that's all very well, but you need to put some teeth behind it. And if you look at section 366, that's where the director or a board of the Commonwealth Reserve must prepare a management plan for each Commonwealth Reserve. And so we then see the layering effect of the international obligation, the power under the federal legislation for the Governor-General to make a declaration, and then so on down to the administrative level, the executive level, where the management plan is then prepared for the Commonwealth Reserve. I'll just highlight the Great Barrier Reef as well. One of the reasons for that is that, perhaps unusually in this context, in environmental law for the Commonwealth, the Great Barrier Reef has its own act, the Great Barrier Reef Marine Act 1975, and that is the primary act relating to the marine park. Okay, well, apart from the Commonwealth, there are the state pieces of legislation that are relevant. I'm going to highlight 2. These are probably the 2 most important ones in Queensland. There's the Environmental Protection Act in 1994 and the Vegetation Management Act of 1999. Firstly, dealing with the EPA, as always, when considering a piece of legislation, I would recommend that you look at the objects or purpose of the Act. In this case, it's Section 3 of the Act, and it provides that there is an obligation for protection of Queensland's environment, but with a catch. And the catch is this, that in doing so, there must be an allowance made for development that improves the total quality of life, now and in the future, in a way that maintains the ecological process on which life depends. So the EPA gives preeminence to the ongoing welfare, that is the quality of life, of human beings. And development clearly refers to economic development. So if we go back a couple of weeks ago, we were talking about the definition of ecological sustainable development. And remember, of course, that it's not just a matter of the dealing with the environment, but it's also dealing with those other issues, including the economic. And the EPA, therefore, reflects that general principle of ecological sustainable development. In the context of protecting the environment, we need to consider what are the sanctions, what are the mechanisms that can be undertaken by authorities in particular to deal with issues. One is criminal prosecution, but it's by no means the only way that action can be taken to protect the environment or to restrain offences or punish for offences that are undertaken. So if we look at the Environmental Protection Act, I'm going to ask you to look at Section 319. Now this is interesting because that particular section places a general environmental duty on all members of the community to ensure that environmental harm is minimised. So it's a really catch-all section, and I like having catch-all sections that you can keep in the back of your head, because if for a moment you're lost for an argument, you can always go back to an object section of an act, or you can go back to a general duty section of an act and argue from that point onwards. So have a look at Section 319 of the Act. Now, while you're looking at the Environmental Protection Act, I'm going to ask you to consider the mechanisms by which action can be taken to remedy or restrain an offence against the Act, or something that might be threatened as an anticipated offence against the Act. And have a look at Section 505, subsection 1 of the EPA, because it provides that a number of people can bring action, and the Act says that it can be the Minister or an administering authority or someone whose interests are affected by the subject matter of proceedings, or someone else with the leave of the court. And all of those people have the power under that section, 505 subsection 1 of the EPA, to bring an application for an order of the court to remedy or restrain an offence against the Act. So that's really quite different to what we're used to. We're used to police prosecuting offences. But in this instance, under the EPA, when it comes to environmental offences, the potential number of parties that can take action is much broader. When you're considering the Act, I'd also like you to consider some specific sections. These are in your notes, but sections 437, 438, 440, 442, 443 and 444. And all of those really deal with offences that create harm to the environment, and it provides some statement about causation. So, for example, in 437, subsection 1 talks about a person willfully and unlawfully causing serious environmental harm. Subsection 2 is watered down a bit because it only talks about a person not unlawfully causing serious environmental harm. So the willful component is removed from subsection 2. Now, it may be that a party has a defence to an action that is brought against them in those circumstances. And it is a defence to prove that the harm occurred even though the defendant was complying with the general environmental duty by complying with the relevant code of practice or in some other way. All right, now the Vegetation Management Act 1999, substantial amendments in 2013. You should consider that. Once again, have a look at the objects or purpose of the Act, Section 3, and part of it is to ensure there's a maintenance of ecological process, reduction in greenhouse emissions, all those sorts of things, allowing for suitable land use. But have a look at Section 3 in that regard. Also, and I think this is in your notes, consider the issue of penalties imposed by courts, both at state and federal, when it comes to land clearing. I'll deal with state first. There's a New South Wales case, Newcastle City Council against Pepperwood Ridge. It's 2004. In that case, there was a plea of guilty. The court provided a discount on penalty because of that plea of guilty, 15%. However, the gravity of the offending behaviour was reflected in the fine. In that case, the court imposed a fine of $68,000 for illegal tree removal, which involved gross negligence, not necessarily willful act, but gross negligence. And that was actually a substantial discount on penalty because the defendant undertook to pay the prosecuting counsel's costs. And at 31, they estimated that at between $100,000 and $150,000. So the overall penalty was over $200,000. A somewhat similar ultimate penalty was found in a federal case of Minister for the Environment, Heritage and the Arts against Lamentina. And in Lamentina, 2009 FCA 753, the federal court dealt with a prosecution arising from action likely to have a significant impact on a threatened species. And that was in contravention of Section 18.3 of the EPBCA. In that case, the court imposed a penalty of a fine of $220,000 and ordered that the defendant pay costs in bringing the application, which were fixed at $22,500. So a similar dollar amount, but a very different way of arriving at that figure. All right. In terms of other important issues on what to do to protect the environment or to deal with issues in relation to climate change, for example, then have a look at some sections of the Planning and Environment Act, the Sustainable Planning Act, and think about how the Planning and Environment Court can operate by using the sections that conferred upon it by Commonwealth. Have a look at section 456 of the Sustainable Planning Act, and also have a look at and that's a declaration provision, have a look at sections 601 and 604 of the Sustainable Planning Act as well, because they deal with the issue of mandatory injunctive relief, which is really where the court makes an order, essentially forcing someone to do something. So you've got declarations, which is the court making a declaration about what the legal position actually is. That's 456 of the Sustainable Planning Act. If you're prosecuting, you might think, well, that's sufficient. Alternatively, if you want a bit more teeth, have a look at section 601 and 604, which deal with enforcement orders and mandatory injunctions. Now, a good example of the latter, which is 601, is the Fraser Coast Regional Council against Burn Brothers. Now, you'll see this, it's not a cited decision in terms of in the law reports, but if you go through courts and the party search, civil search, you'll find it, and I'll show you that in a moment. But what you will find if you go and look at this case is, and I trust you will, the applicant sought an enforcement order pursuant to section 601 1A of the Sustainable Planning Act, and the order that was sought was to restrain the respondent from carrying out assessable development, which was a material change of use for extractive industry, unless and until the conditions of a development permit for that material change of use from extractive industry granted in respect to the land were complied with. So in terms of how to get to that case, and I think we've done this before, but I'll share the screen and just go through that with you. Sorry, we're getting there. Just bringing up the page. Okay, you can see now, Queensland Courts. Have a look here at Search Civil Files. You'll see Party Search. Gives you an opportunity to type in some details. We'll put in Fraser Coast Regional Council. We'll search for Fraser Coast Regional Council. And shortly we'll see a list of litigation matters involving the council. And the beauty of this particular search is that it's not just a matter of seeing the final decision, but you actually get to see all the documents on the way through. And there we are, no. Where is it? Sorry. I think I just raced it straight past it. There it is. Byrne Brothers. If you look at the file details, you'll see the documents lodged in that particular case and the orders that were made. Okay, so I'll stop the share now. The other thing is, in terms of the weekly problems, please continue to look at that. And last week, there were some issues to do with environmental impact assessment. And in terms of the response to the questions, I'd recommend that you look at the study guides that I wrote. In particular, have a look at paragraph or point 2.0, dealing with environmental impact assessment. 3.0, dealing with intergovernmental accreditation. And 5.0 is also relevant, which deals with matters of national environmental significance and controlled actions. All right, well, my voice is going. You could probably tell that. Thanks for joining us tonight, and I hope to have some feedback for you in relation to the first assessment piece very soon. If you have any questions, please ask through UCrew, and all the best, and we'll see you next week.